to learning fund from the Norwich Law School, UK. Notably, during his LLM at Norwich University, he represented his school in the prestigious Oxford Intellectual Property International Moot Court Competition 2006. He had obtained his PhD from Guwahati University for his research work on legal and constitutional protection of traditional knowledge of indigenous people of Northeast India. He also obtained PG diploma in various areas like human rights, refugee laws, environmental laws, and others. Further, he co-authored the chapter on cyber privacy in book Legal Dimension of Cyberspace 2004 and edited many important works pertaining to cybercrime, human rights, and others. He has brief engagement with various regional and national newspapers as a freelancer and the Kobdo.net. The world's first online English-Assamese dictionary is edited by him. He has authored more than 200 articles, including journals, and more than 10 of them are documented in Indian Parliament. Furthermore, Dr. Deka's contribution in various important international agencies like the United Nations High Commissioner for Refugees, Red Cross, and other is notable. Currently, he is serving as an advocate in Guwahati High Court. Alongside, he has also been a visiting faculty in many prestigious universities, including Guwahati University, ILI, New Delhi, etc. So I, on behalf of the organizing team, take the privilege to welcome you, sir, to this seminar. So now we'll start our technical session. Neelotpal, sir, the platform is all yours.
Thank you very much, Preeta, and thank you very much for joining us, Professor Dr. Valla sir, and all the participants. I'll start with I'll start with the basic concepts regarding intellectual property, then the traditional knowledge, and then a bit about geographical indications. And later on, I'd like to concentrate more on the constitutional part of the fact that how we can protect the traditional knowledge as far as our constitution is concerned, and what is in the constitution and what is not in the constitution for the protection of traditional knowledge, which is an emerging area in the intellectual property. I'll be going very briefly about the conceptual aspects of traditional knowledge in intellectual property, then the indigenous knowledge, and also about geographical indication. Very, very briefly, I'll go about it. So, what is intellectual property? While trying to understand the concept of intellectual property, we need to follow a sequence to understand the concept. That is, I'm trying to simplify it because I'm told the students will also be participating in this webinar. So the sequence is that our intellect, which is the mind or the brain, intellectual is which you or someone or anyone that is connected with or using a person's ability to think in a logical way and understand things. Finally, intellectual property, which is an idea that somebody has created, and law prevents others from copying. In the intellectual property, we have different areas like patents, copyright, trademark, geographical indications, and many things, which we can go for register. There is an national as well as international regime, how we can protect them, how we can register them. So whatever be the intellectual property, that will be the creation of my mind, be it a patent, be it a trademark, be it geographical indication, be it copyright. Then this is a brief about the intellectual property, which is being the Article 28 of the Convention establishing World Intellectual Property Organization. Here we can see, let me read out. Intellectual property includes literary, artistic, and scientific work, performances of performing artists, phonograms, broadcast inventions in all fields of human endeavor, scientific discoveries, industrial designs, trademark, service marks, and commercial names and designations, protection against unfair competition, and all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic field. This definition is basically the codification of various types of intellectual property that has come up with the establishment of the World Intellectual Property Organization. Now, let us see. As I have told, my plan of presentation will be from the indigenous knowledge to traditional knowledge to geographical indication. For that matter, let us see some conceptual things like the indigenous. What does it mean? Indigenous, so far as the international or the national codification is concerned, there is not an acceptable definition for indigenous. Now, originating. So, what does it mean? Originating or occurring naturally. I'm trying to find it out from a dictionary. I have followed the Collins English dictionary, which properly suits for our purpose at this moment. So, originating or occurring naturally in a country or a region, native or innate, that is something inherent and specially of flora and fauna, produced naturally in a region, belonging naturally to soil, etc. This is something what is indigenous. As I have gone through the dictionary, because there is not a single acceptable definition in the entire world regarding the indigenous or indigenous peoples. Now I'm coming to the indigenous peoples. Now, what is people? This is J. Martinez Cabo. So he has been the special rapporteur of the United Nations Subcommittee on Prevention of Discrimination and Protection of Minorities. Now, let us see the definitional aspect of the from the United Nations Special Rapporteur. What does it mean? Those which having a historical continuity. This historical continuity is important, with spatial invasion, with pre-invasion and pre-colonial societies that developed on their territories, consider themselves distinct from other sectors of the societies now prevailing in those countries or part of them. They form at present non-dominant sectors of the society and are determined to preserve, develop, and transmit to future generations their ancestral territories and their ethnic identities as the basis of their continued existence as peoples, in accordance with their own cultural pattern, social institution, and legal system. These three phrases: existence of indigenous people, own cultural pattern, that is, which is, it will be very important, the social institutions and legal systems. So this is briefly about the indigenous people, where it will be important about the historical continuity about those people, about the indigenous people. Then that has to transmit. That has to transmit from a pre-invasion and pre-colonial societies. That will be what will be important, and they'll be having their own cultural pattern, social institutions, and legal systems. That is about the indigenous people. Now this is about indigenous knowledge. That is IK. IK is used to describe knowledge held and used by communities, peoples, and nations that are indigenous. IK, knowledge that has been possessed from centuries, that is very much innate to their soil. So that is from where we get the indigenous knowledge. Now, what is traditional knowledge? In the contemporary world of intellectual property, traditional knowledge is recognized as intellectual production, which is a source of economic and cultural value, especially for local communities in developing countries across the globe. As of now, there is no universally accepted definition of TK. TK has been defined in broad terms by various international organizations and scholars as a diverse range of tradition-based innovations and creations resulting from intellectual activity in the industrial, scientific, literary, and artistic field. Such a broad definition, from performing arts to cultivating agricultural products to, to medicinal use of plants, including diverse intellectual fields, means that TK, traditional knowledge, can be recognized into several subsets, from some of which are designated by terms genetic resources, traditional medicinal knowledge, and folklore. Like in the intellectual property, we have different areas under the umbrella in intellectual property, like patents, trademarks, copyright, etc. Under the traditional knowledge umbrella, we have various genetic resources, and it will include medicinal resources. It will include the flora and fauna from where we have the medicinal resources. Then we have folklore, folk music, which can also be clubbed under the umbrella called traditional knowledge. Then briefly about the geographical indication. A geographical indication is a sign used on products that have specific geographical origin and possess qualities on a reputation that are due to that region. In order to function as a GI, a sign must identify a product or originating in a given place. In addition, the qualities, characteristics, reputation of the product should be essentially due to the place of origin. Since the qualities depend on the geographical place of production, there is a clear link between the product and its original place of production. Like in France, we have the champagne. Like we have in Assam, the Muga silk. Like we have Darjeeling tea. The place of origin, the taste will differ. So the taste will differ if we have, if we want, if we plant a tea in the other region, we will not get the same place. The champagne, the taste of champagne will not get in any other place except in the place called champagne. So the qualities, characteristics, or reputation, or place of origin, that is what matters for a registration nationally or internationally as a geographical indication. Now, the correlation between indigenous knowledge and traditional knowledge. Indigenous knowledge is obviously the traditional knowledge of the indigenous peoples. Indigenous knowledge is therefore part of the traditional knowledge category, but traditional knowledge is not necessarily indigenous. So, traditional knowledge will be covering the entire set of indigenous knowledge. That is to say, indigenous knowledge is traditional knowledge, but not all traditional knowledge are indigenous, because traditional knowledge can have very recent origin, maybe 200 years old, maybe 100 years old, maybe 50 years old. Tradition can be developed in a very limited span of time. But to be an indigenous knowledge, it has to be centuries old. It will come from various it takes time to develop as indigenous knowledge as in centuries. Now, this correlation is given by J. Mugabe in his book called and published by World Intellectual Organization in a journal called Intellectual Property Protection and Traditional Knowledge, Intellectual Property and Human Rights. That is where he tried to relate between indigenous knowledge and the traditional knowledge. Now, the correlation between traditional knowledge, indigenous knowledge, and geographical indication. All IKs are TK. This correlation is very important. All TKs may be IK, may not be IK. All GIs may be TK. Some GIs may be IK. Some GIs may be TK and IK both. Later on can get the geographical indication registration, like the Muga silk in Assam. Some GIs may stand independent of TK and IK. What I say, some GIs may be TK and IK both, and later on can be can get GI registration. As regards the Muga silk is concerned, the GI registration, yes, the quality that matters, the reputation the Muga silk in Assam has, that is qualified for the GI registration. At the same time, never to forget the indigenous knowledge, centuries or seen centuries about the Muga silk, that is important. And then traditional knowledge, how we what we do with the TK and how we develop the TK. So we cannot ignore about the Muga silk in Assam regarding the geographical when we come to the geographical indication. So Muga silk can be branded as IK, TK, and geographical indication altogether. Now, why I say Constitution of India? Across the world, there is no domestic legislation to cover the various areas of traditional knowledge or indigenous knowledge. Some countries have some legislation, but there is only mention of traditional knowledge, but it is not something like that the act or a legislation is specifically meant for the protection of for the protection of traditional knowledge. So here I'm trying to bring in a corollary application of the constitutional corollary of the minorities to the indigenous peoples, cultural and educational rights, fundamental right, Article 29 and 30. Why Article 29 and 30? The framers of the Constitution of India, they have given much importance to the Article 29 and 30. When I go to the parliamentary debates, I could find that how people from the various parts of the country, they have advocated for, they have vouched for the fundamental right under the Article 29 and 30, which meant for the cultural and educational rights of the minorities. Now, why minorities? Minorities because these minorities we can see in the various pockets across the country, small groups, small areas. These minorities may include cultural minorities. These minorities can include religious minorities, like we have Christian, Jews, Muslims across the country. They're prone to exploitation by the majority of the people. So that is why there's framers of the Constitution of India were so serious. They have made cultural and educational rights as the fundamental right for the minorities. Now, bringing a corollary between the minorities and the indigenous people, I could see that these indigenous people, like the minorities, living in various small pockets across the country. North is being the hub of the traditional knowledge and of the indigenous knowledge. Now let us see Article 29, what it talks about. Protection of interest of minorities, that is any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. Number 2, subclause 2, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds for on grounds only of religion, race, caste, language, or any of them. Now, Article 30, it's a big one. It talks about right of minorities to establish and administer educational institutions. All minorities, whether based on religious or language shall have the right to establish and administer educational institutions of their choice. Then we come to subclause 1A. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority, so and so. And then subclause 2, the state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Now, why I am trying to bring a corollary, like the minorities, there are indigenous people living in different parts of the parts of North and Assam, Northeast India, and across the globe. Now, talking in terms of India, the constitution, what I prefer, that there should be one article that protects the rights of the indigenous people as far as their traditional knowledge is concerned, like minorities as far as their educational cultural rights are concerned. So that is being the corollary. There should be one article for that. Like the minorities in Northeast India, the minorities across the country, they are prone their traditional knowledge, their indigenous knowledge, and which can later on be a geographical indication. Although most of the most of the traditional knowledge will not be qualifying for the geographical indication, but they're prone to exploitation. How? By the by various international medical companies, medicine companies. They can come to India as a tourist, and any sample for a particular disease collected can be tested in a laboratory, and there can be and the medicine can be made out of that. It will take a very few days time to make it to make it in a laboratory, and then patent it, and then billion-dollar business, maybe $1,000 billion business across the globe. That is how we are in a risky in absence of a proper legislation for the legislation for the protection of indigenous knowledge and the traditional knowledge. We had of late the geographical indication. We have of late integrated circuit layout design legislation across the globe. In India, we have it, Integrated Circuit Layout Designs Act. We have now traditional knowledge being in the public knowledge. There is a concept called prior art. So it comes under the prior art. So traditional knowledge cannot be qualified for the protection under the various aspects of the intellectual property, because it is already a prior art, because it is already in the public domain. We cannot have it, but we have to protect it. How? My idea would be to have a umbrella legislation like intellectual property, where like when we can call it that the traditional knowledge and then we go for the classification of it, where we can find traditional knowledge, like we say patent is, yes, it's an intellectual property. We say traditional knowledge, it's a we say trademark, intellectual property. Like that, there can be an umbrella called traditional knowledge of the indigenous people, and then we can go for the classification of it. How we classify it? We can say copyright of we may or may not use. It depends on the legislators. Now we can see that the music, traditional music, that is also a traditional knowledge. Then folklore, folk stories. Those can be. There can be a kind of copyright for those. There can be patent kind of traditional knowledge, where we can say, yes, this is eligible for, this is a kind of traditional knowledge, medicinal knowledge, where should be similar, where there should be similar legislation at par with the patents. We cannot get the patents for the traditional knowledge which is already in the prior art. That is why the importance of new legislation for the protection of the various classification that we can have under the umbrella called traditional knowledge or the indigenous knowledge. This already I have covered that the indigenous people are living across India in small pockets in almost every state in India. Traditional knowledge and indigenous knowledge belongs to indigenous people. That is what we should keep in mind for the protection of traditional knowledge. And TK and IK in relation to indigenous people, a kind of universal all over the country and all over the world as well. In India and across the globe, there is strong opinion for human rights to traditional knowledge of the indigenous peoples or the tribal peoples. It is more important in India as every state of India houses indigenous people, and Northeast India houses most of the indigenous peoples, and they are the owners of indigenous knowledge. So we need to keep in mind indigenous knowledge is clubbed under the same category of knowledge that is called traditional knowledge. So now, what we can have, we do not have, if we have, say, we talk about human rights. So we have a Human Rights Act prevailing in India. And similarly, there are fundamental rights that is under the Constitution of India. Then we have, if we talk about human rights, then we have Article 21. So we can have there is something in the Constitution of India in the form of an article. Article 21, it talks basically about the human rights. So we have a Human Rights Act. We have articles for respect of international legislations, international obligations. So we have various Geneva Conventions pertaining to different fields, but we don't have an article on in line with the traditional knowledge of the indigenous people. So we don't have a legislation on that, because we have Article 29 and 30 covering the minorities for the educational and cultural rights. We have a Protection of Minorities Act, or various Scheduled Castes and Scheduled Tribes Act for that matter, because of Article 29 and 30. So for the minorities, we have that. But the framers of the Constitution of India, I won't say with due apologies to the framers of Constitution of India, I dare to say that there was no importance given that for the indigenous knowledge of the traditional knowledge. So in the same line with Article 29 and 30, which we can tell that Article 29 subclause 2 or subclause 2, where we can talk about, where we can find a headline that the traditional knowledge of the rights of the indigenous people regarding as regards their traditional knowledge. And in a similar manner, we can have on the Constitution of India a fundamental right, because these indigenous people are also the indigenous. I can use the term indigenous minorities across the country. So we can have similar articles in the same line for insertion in the Constitution of India. My presentation is not delving much into the connotation and denotations about the traditional knowledge, indigenous knowledge, and geographical indication. Entire presentation that what I want to bring in is that the importance of having indigenous knowledge of traditional people in the Constitution of India. I could have gone through the definition aspects, discussing the various legislations regarding various intellectual property, various traditional knowledge, but my importance being, my stress being on the insertion of a new article in the Constitution of India. I expect that that today's participants will understand we will understand the importance of insertion of a new article regarding the traditional knowledge, and they will take it to their own states, their own places, where they can see the importance of protection of traditional knowledge. At the same time, like the Constitution of India talks about the protection through the state funding of the indigenous of the minorities and their various and the various things are being suggested for the state funding for the protection of minorities educational and cultural rights. What we can have similar funding, or we can have a legislation, maybe it can be called Protection of Traditional Knowledge Act, maybe in 2020. I may be very optimistic, and maybe in 2001, 2022. So I am expecting a legislation to come up, and participants will take this message to the entire country in their own places. And if not through the state funding, we can see there are discussions regarding creation of trust in the name of various indigenous people. We can think about a legislation which talks about creation of trust, taking some indigenous people as well as the administrative officers from the government in the trust, for the development of the trust, out of the incomes that can be generated from the traditional from the traditional knowledge, and for the sales out of traditional knowledge of the indigenous knowledge. With this, I conclude my presentation, and I'd like to I'd like to see any questions which I can reply.
One of the queries, Neelotpal sir, a very good presentation indeed. One of the questions I see is to have a reflection on TK Bill 2016.
Yeah. Yeah, TK Bill, yes, TK Bill 2016 is there, but as of now, we don't see the legislation coming up. And my stress is, Professor Sir, my stress is on having, first let us have one article in the Constitution of India. And then it will open up it will open up everything for a legislation for the TK bill.
No. See, the query is to have a reflection what is laid down in the what is proposed in the bill. Yeah. The participant wants to know.
Yes.
The details, salient features of that particular bill.
Yeah. The important features they can I can see it in the TK bill. Yes, there are proposals are being made in the TK bill for the creation of trust, that then the government level and the administrative level that is being there, and then the sharing of the traditional knowledge, how to share it, because as there are prior arts. The sharing is made important here while proposing as far as the proposals are concerned. This is basically the substance of that. But regarding the administering part in the TK bill, I have a little bit of confusion, little bit of doubt regarding the administering part of it, because what the TK bill suggests is not including not including much of the people from the indigenous people we can talk about, because of their education level is not that high. But equally in the TK bill, what it should be, that there should be one clause, one section for the education part of the indigenous people, and at the same time they should be educated regarding their regarding what is intellectual property, how it can be developed in them. The education part is missing in the TK bill. That is what should be one of the features of the TK bill.
I heard about I heard it as a will, because will also today, I think since by default I heard the word as will instead of bill. I think so today I have been doing a lot of registration of wills in which we are adding all these digital assets of the owners also, because this is some part where people are not including it into their will, which is their last testament of their life. My suggestion is when people execute a will, it is better that they also declare their digital assets, their hard disks, storage disks, or their data or software developed by them, or the artwork developed by them. And like when Roerich, the famous Russian painter who died in Bangalore, who was married to Devika Rani, the film actress, their entire assets is taken over by the Chitrakala Parishad. There was a big dispute regarding the will executed, and some other people were involved in fraudulent activities in getting the will done, and a lot of these artworks were not part of it in some of these things. So government took over this finally and gave it to the Chitrakala Parishad. I have seen a lot of in my personal experience, digital data is never found a place in the wills executed by people. Okay, they only write their car, they write their assets of immovable property, and they forget some of the movable assets also, including, I am telling people to even write in their will that they had an LPG in their name, this LPG should be transferred to so and so. Otherwise, in our country, it's a Herculean task. Getting anything transferred into the name of the legatee is a big task in this country. Okay, and a lot of wills are being disputed on these grounds because some of things have been left out and no residual clause is mentioned, that notwithstanding anything not mentioned left out in this will, that shall go to so and so. I think digital data, digital software data should also be, and geographical indexation or trademark registered, whatever is there, should also be a part of these wills, I think so.
Yeah, like I'm really grateful to you for enlightening me in this area, and at the same time, that I have skipped in my presentation that regarding the digitization of the traditional knowledge, we already have. Regarding the traditional knowledge, we already have a traditional knowledge digital library, and that is being done in cooperation with the government of India, and that is being saved in the World Intellectual Property Organization. Where the digitization is done, but today what we are talking about, digitization will not be enough. We need to have the proper legislation for the proper protection of the traditional knowledge.
Yeah,
but I'm really enlightened for the yes. I'm really enlightened for that.
The data protection bill is now before the committee.
Right.
The data protection bill is before the joint parliamentary committee. It is constituted by the thing, and they're yet to submit their final report on this.
True. Sure.
Data
Thank you
protection
very much.
policy. I have another point to be mentioned here at this juncture. See, all sting operations done by media houses, okay, sting operations done by media houses, the data in their possession, which is clandestinely obtained in a sting operation, okay, that data, who is going to be the custodian in this country? See, all other data protection law may cover, but sting operations by media houses, by any other authority, who is going to hold these data, as where will they give this data finally after the sting operation? Somebody should be the custodian of it. Otherwise, that sting operation data can be used for exploiting, making ulterior gains from the people who are subjected to the sting operation perennially also, which you see in cyber stalking, in crimes, in cyber crimes. You see a lot of people, pornographic videos being photographed at gunpoint, and of girls and things, and then being blackmailed and this. So this data storage, see, under the IT Act now, there is a provision where the government can put up an agency under Section 69 and to go in and take over that storage disk from the houses also. The storage disk includes your external hard disk, includes your computer, laptop also can be taken away, like what you see in IT raids and search and seizure, where they take away all your things, because storage devices, because they may contain some valuable data for them. That is why.
Yeah. So data storage can be, as a cyber lawyer, I can say, like, I have to be very religious as a lawyer. So as a religious as a lawyer, what I would say, the custodian of that, if I give a legal opinion, it has to be with the government, and legislation should be made. Otherwise, it will not go to the government.
In the absence of the present scenario where there is no legislation, all the sting operation data is with the media houses still. We need to have a Data Protection Council of India is the body under which these data should be actually stored.
True. And they, when it is the custodian for the sting operation, custodians are at present the media houses.
Yes.
But something has to be done with in cooperation with the Press Council of India.
Exactly.
So Press Council of India has to be consulted by the government of India. What can be done, and probably I'm not aware about that. Probably there is a committee for this.
And even the Broadcasting Corporation of India, Prasar Bharati Broadcasting Corporation of India is there. They also need to step in to see that these things are not left to lie idle with the media houses. Once it is over, that should become the property of the state. Otherwise, a perennial exploitation can happen on all these data.
True. Very true. So thank you very much, sir, for enlightening me on this.
Pleasure, sir. Pleasure. I came in late. I had some will registration to be done. That's why.
It's okay, sir. Thank you, sir. Thank you.
There's one question from Dulumoni Boysa.
Yeah.
Sir, TK and IK is the universal. What does it mean?
What I say, TK and IK, that is universal in India. What I mean to say is that TK and IK we can see in all parts of the country. TK and IK. We can see TK and IK any part of the country. Maybe the small pockets, like minorities. That is a universal concept. Like the minorities is a universal concept. We can have those minorities in small pockets in the entire country and in the entire world, in small pockets in various countries, in various states. That is why I said TK and IK, as far as the indigenous peoples are concerned, that is universal in India. That is universal across the globe. That is what I meant by that. Yes, Prita?
Yes, sir. I hope the question is clear to Dulumoni Boysa. Okay, so we have next questions. Sir, are there any specific criteria for categorization of a community as indigenous community? Specific criteria for categorization of a community?
No, as of now we don't have. The world doesn't have, because the entire world is not agreeing to the fact that there should be a definition And although there is some definition regarding the indigenous, word indigenous, and regarding the two words, indigenous people, there are some definitions about that. In India, we are yet to arrive at a definition of regarding indigenous and or indigenous peoples. So that is why the criteria for categorizing a community as indigenous, that is not in place as of now.
Okay.
Regarding categorizing indigenous people, maybe Justice Biplab Kumar Sharma committee in Assam, if they have submitted a report regarding who is indigenous Assamese. The report is yet to come out. It is submitted to the government of Assam, and then government of Assam. We people are not sure whether it is submitted to the Prime Minister of India, to the government of India. We are not sure about it. Government is not vocal about it, not clear about it. If it comes to the public, who actually indigenous Assam is, probably in that case will be able in future will be able to categorize who is indigenous, who is not indigenous. Thank you very much. Yeah.
Sir, I hope so. The word indigenous is itself a confusing word because everyone have a different definition regarding the word indigenous.
True, because the places are different,
Yes,
their
sir.
culture is different, so it is very difficult. Like we have one convention, a convention on human rights in America. We have convention on human rights in Europe, in Africa. But in Asia, we don't have a human rights convention because we have various caste, creed, and culture, and people are not able to agree on the matter. We don't have
Yes,
Asian convention on human rights. Like that, what you were saying, the indigenous,
Yes, sir.
same thing applies. Because of that, we don't have an agreement on the word indigenous or indigenous people.
One question from Dr. Pranay Kumar Aditya.
Yeah.
Like digital library, responsibility of central and state authorities to register traditional knowledge.
We have committees in northeastern states as well for the digitization of the traditional knowledge, but that is not done dedicatedly. Otherwise, we have some books where we find big thick books on the traditional knowledge, but digitization and making it the public domain, state-wise or place-wise, or in our entire country, it's not done dedicatedly. Otherwise, also we have one traditional knowledge digital library with the World Intellectual Property Organization, and those digital library, that digital library, when it is being maintained, there is no classification. There is no classification made of the traditional knowledge that we have in India or in any parts of the world. No classification is made of the traditional knowledge. So digitization will come up, but for that matter, if we want to work dedicatedly in that area, the one act has to come up, and as a forerunner of that probable legislation in future, we should first have one article legitimizing the indigenous people and indigenous people as regards the traditional knowledge. But again, the problem arises: who are indigenous people in India? The definition will obviously differ in every state of India. So government has to take up good legislatures for making the definition of indigenous people.
From Chandita Sharma. Some GI may stand independent of traditional knowledge and indigenous knowledge. Sir, can you please give an example or better understanding?
I don't know. I don't know when. Yeah. Repeat. Yes.
Some GI may stand independent of TK and IK.
Yes.
So could you please give an example or better understanding?
For that matter, the Darjeeling tea. Darjeeling tea, we have earlier we had a trademark kind of thing. Now that is a GI, Darjeeling tea. We don't have any traditional knowledge background to that. We don't have any, and for that matter, in Assam, we are trying to have Assam tea as a GI, but we are unable to do it because this is something that is the Britishers had found it out. It cannot be a traditional knowledge. It cannot be a indigenous knowledge. But as far as the GI is concerned, this will be an independent kind of GI. If Assam tea can be made independent of traditional knowledge, independent of indigenous knowledge.
Okay.
And any other example for GI, for that matter, can be. We don't have exactly that, but most of the GIs will be having some kind of indigenous or traditional knowledge link. Most of the GIs. If it has to be of, when we talk about the traditional, when we talk about the GIs, what is important is when we produce it, the place of origin, the qualities belong to that place of origin.
Like the Nagpur orange, sir?
Yes, yes.
Like the Nagpur oranges?
Yeah, Nagpur oranges, yes, yes.
Alfonso
mango, yes. So those have geographical indications, but they do not fall under TK and IK, isn't it, sir?
Yes. True.
So I hope the query is clear to Chandita Sharma.
There's some, I saw some query on 19.1, Article 19.1D and 19.1G. Some Deepabali Brahma. Sir, when we talk about geographical indication in IP, how Article 19.1D and 19.1G and taxation on or tax law is going to play a role? There is a query somebody has raised.
To be frank enough, I am not a tax expert in this regard.
Right.
So I will not be taking the question for my reply.
No,
so if it is
on 19.1D and G also, I don't understand why this query has been come on 19.1D and G. D is right to move through the territory of India. And
right.
19.1G is to practice any profession, trade, commerce.
True.
You as it is, you all have, everybody has that right to practice any profession. And I am unable to understand what has it got to do with geographical indication in IP law. 19.1D is free movement through the territory of India. GI can move around anywhere in the world also.
True. The question, maybe Deepabali Brahmas is not able to put it in a correct frame.
Yeah, probably.
Maybe
Indian, we shall give her a chance to interact with you.
Sure. 19.1D, she can.
Sir, next question from Shruti Basmutari.
Yeah.
Speaker sir, under which intellectual property does indigenous knowledge fall?
No, the indigenous knowledge doesn't fall under the intellectual property. It doesn't come under that. That is the importance of tradition. That is why the importance of traditional knowledge. Because there is no legislation accepted by entire world, except by entire India, there is no legislation regarding traditional knowledge. That is why it cannot be clubbed under the umbrella called intellectual property.
Shruti, are you clear? Because sir says that unlike Patent Act, Copyright Act, unlike all these, the indigenous knowledge, like any other in the world, doesn't have a legislation yet.
Yeah.
Okay, so it categorically may not fall under intellectual property, but however, geographical indication is a result of human intellect and that have been practiced since many ages from our
True.
past
True.
generation.
Yeah,
Isn't it, sir?
Yes. Then I can see, Prita, I can see one question. If GI is given to a particular product item is not renewed for 10 years as given at a different body. These questions I would not like to reply this question because what we are, our topic is different today because it will take me lots of maybe few hours to reply it. The question is not to the subject concerned. We are discussing today.
Rita ma'am, it's from Anjali Datta Brahma.
Okay.
The question is that can you please explain once more about the relationship between IK and TK?
IK and TK.
Relationship.
TK is a wider concept than the IK. Indigenous knowledge that comes that may be centuries old, but TK can be centuries old as well as TK can be developed in a span of 100 years, 100 years, 200 years. TK can be developed. So all indigenous knowledge are traditional knowledge, but all traditional knowledge may not be indigenous. That is the difference between traditional knowledge and indigenous knowledge.
Okay. The next from Arijit. No, that we are done. From Linjoti Bora. Except GI Act, thus traditional knowledge will get protection under any other IPR law, such as patent, trade secrets, etc.
See, and under the Patents Act, protection is there for traditional knowledge, but not under the IPR thing. It has got traditional knowledge protection under Section 25 and Section 64 of the Patents Act.
Regarding this protection of traditional knowledge under the Patent Act will be a difficulty because the traditional knowledge is already in the public domain. That is a prior art. No prior art can have the patent. But there will be a difficulty in traditional knowledge having as a patent registration.
No.
Those prior art has been in the WIPO Intellectual Property Organization. We have a digital library. As Hari sir has is very much vocal about the digitization. So if I talk about that, we already have it. Prior art cannot come under the patent registration.
Under copyright section 31A provides protection to unpublished articles and things like that. Under copyrights section 31A, okay, provides protection to unpublished Indian work and things like that. That is one way of giving protection. Under section 25 and 64 of patents law, you have a right to revoke the patent. That is a protection. Right to revoke also is a protection.
True.
An indirect protection, though it is not a direct protection. Right to revocation is an indirect protection under section 25 and 64 of the patents law.
True. That is why the revocation can be done. That is why the case of the Basmati Haldi, all those in the US patenting. So that is why that happened.
That's true.
Yeah.
Okay, sir.
Granting permission is one way of protection. Granting permission under any law is one protection. Continue to see that they maintain that permission and is another protection. By revoking somebody else trying to interfere with your thing is a protection. Indirect protection under the patent.
That is absolutely
correct, no, sir? I hope you agree.
Absolutely. Absolutely. Yes.
Sir, a question from Dr. Mosumi Kalita. What is the difference between geographical indication and indication of source?
You see, indication of source is the source code. Source code. See, all your Paytm, ATM, all these social platforms through which you pay, UPI, all these things, they're all part coming under the source code. Indication of source code. You may have to share. Suppose a Swiggy platform you engage as a partner through which you will like to deliver your food packages and things like that. Then the consumer pays through some online platform. Okay, there is a source code for that. Okay, that is that source code which will be shared by this food operator with Swiggy. Okay, so that Swiggy will deduct what is his service charge and see the remaining comes to the food operator. Okay, so this is that source code under the software law. There is a source code. Codification is done in software industry.
Arisa, probably the question is, what is the difference between geographical indication and the source?
Indication of source.
Yeah,
I don't know which source is it. The source code area which is talking, or what is the source?
Is probably not the source code area. What does means to say? Probably what I can understand is geographical indication. Okay, it is coming from a particular place. Now,
from where it is originating. From where it is originating.
Source. The source is something.
Location.
Location. So what
geographical
is
location.
Yes. Geographical location.
There will territorial location.
Yeah. The source. The source is the basic of geographical indication. I'd like to see participants' views in this regard, because this is a question probably she has studied somewhere. So that is why I'd like to see the participants' views, if there is any way that I can connect to the participant.
Actually, I got this question earlier only. Means I have attended one seminar at that is Assam University, Bansar Diffu. Okay. So there one question raised regarding it, like there means in Karbi Anglong, their Ginger is having their geographical indication. So one of the that is presenter, he asked this question. Means he was asked by some listeners about this question, and he was unable to give the actual answer of it, and that is why in Google also I have searched, but actually I did not get satisfaction by the answer of the Google. So I want to make it clear by sir only. That is the main reason of it.
Yeah, like what is the difference between source and the geographical indication?
Yes, sir. Yes, sir.
Knowledge for all indigenous knowledge,
yes,
and for geographical indication, there will be sources. But which source will be qualified as a indigenous knowledge? Which source will be qualified as a traditional knowledge? And which source will be qualified as geographical importance? That will be the topic discussion when we go for a repetition of the same. Source is a source.
Yes, sir.
This is the.
See, apart from geographical indication, there is also geographical area codes available based on geographical location. Okay, so they are also called GAC code, GAC, that is geographical area codes. I don't know whether what that question was asked by somebody in that seminar was unanswered, probably because there's some confusion between understanding geographical just source or geographical source code. Third, in software you have a source code, that's a different software source code. But in geographical also, area location, you have a GAC, geographical area code also. Probably that area code can be connected to the GI of the particular thing so that it knows from where the origin is coming. Isn't it, sir?
There is a not suggestion, it's a point raised by Dr. Pranay Kumar Aditya. It's not a question. The bill in public domain, but the bill is in public domain, but the responsibility of the government to tap the traditional knowledge is hardly found as a concern.
True. But that is very important. If when the government of India is talking about, I will not say Prime Minister Narendra Modi, I'll say Government of India is talking about local for vocal, vocal for local. That is the issue. But when we are vocal for local, traditional knowledge and indigenous knowledge will come in, make its appearance first. So it is a very timely statement by Dr. Aditya. It's a very timely comment. I appreciate.
So the question is that can existing IP law provide protection for traditional knowledge and traditional cultural expression?
That we don't have under the existing IPL laws. We don't have that protection. For proper protection, that is why I've been talking about that we should have one legislation for the protection of that. The existing IPR legislations cannot protect the traditional knowledge.
We told
Professor
them that they're only in patent law and the copyright law. We told them.
Yes.
That's the only two protection modes.
I understand that.
Sir, can you please enlighten us about traditional knowledge digital library? What we say? What all kind of knowledges can be put into in that digital library? What all types of things?
Yeah, in that the WIPO digital library that is done in collaboration with Government of India, and in that you will find regarding the it is not the registration. It is not a traditional knowledge registration, but it is just to include some kind of if you have any traditional knowledge in your hand, there is a particular online form. You can submit it online that this is the traditional knowledge here, and then there is an online process where in fact the WIPO can check whether that is already been stated earlier or not, and that is in public domain, and everyone can see this digital library. And when it is in public domain, that bars the registration of those traditional knowledge as which is already in the public domain, that which is being already published, that cannot be again patented. Can again we have geographical indication, and again we can have any kind of trademark or whatsoever. Professor Hori sir has said that there is some kind of protection being given in the patents law.
Section 25 and 64.
But that is subject. Yes, and that is subject to publication or non-publication of those invention or the geographical
unpublished artwork in India, unpublished works in India.
Works in India. But if again that is subject to whether that will last for a long time or not, because there can be opposition to such kind of patents. So WIPO digital library, as Peter wanted to know, you can go online to the WIPO. You can see there will be digital library for the traditional knowledge.
Yes, sir.
When Dr. Moshami was asking on that indication source, see, even in digital library, if I'm not wrong, there will be bibliographic codes, source codes for bibliography and things like that.
Yeah, it is there.
So is that indication source which he was talking in geographic area codes, and local source codes in the library, local source code in a digital library, which may include bibliographic codes also. Bibliographics are stored through a codification.
There is a search option, and we can go about it, and we can see from which country, from which area, from that is being originated. That is there.
Sir, does the traditional knowledge digital library only includes particular subject matter, or it also involves, like for example, in Assam we have Bihu Gamosa, for Boro traditional we have Aronai. So all those the process or the thing, can it be the end product, can that also be included in the traditional knowledge digital library, or only like few subject matter can be included?
A traditional knowledge that will come as a that is Gamusa is a sort of tradition, I'll say. And then this Gamusa in Bihar it will be different, in Maharashtra it will be different, in other states this Gamusa will be coming up in different names. So it is the knowledge is something. This is spinning about the spinning about the gamusa, spinning how we spin it. That knowledge we already have, and regarding spinning we have patents in a different area. Regarding spinning from that coming up from the tradition, it is prevalent everywhere. And when we are not able, we are able to have muga silk because it is having some technological innovations, as well as the from since centuries we have it regarding the muga silk. But regarding gamusa, I'll say this kind of cotton thick yarn we can find anywhere in the country, and Gisilbi is more or less as a culture. We cannot we cannot say Gamusa as a traditional knowledge. That is, but yes, if we can see Gamusa is in our folk culture, that as a folklore to some extent. For the folk literature we can include it as that we can probably include it as a traditional knowledge. But as far as the spinning of the yarn is concerned, it will not be classified as a traditional knowledge. It is a tradition. It is a culture. It is not knowledge. Spinning of the yarn, it is in public domain. We know about it. And spinning in entire country more or less is the same.
Okay, sir. Sir, thank you.
Yeah.
Okay, so another question from Kunjalata Brahma ma'am. Are oral narratives a part of traditional knowledge? Are oral narratives a part of traditional knowledge?
Yes, it's a part of traditional knowledge. Oral narratives, that is part of the yore, part of that has been coming up. That will come as a folklore traditional knowledge. That is true. Oral narrative, yes, it can be, but that oral narrative may be a folklore of a story, of a song that is prevalent since centuries, generation to generations. Those links has to be established. Then it comes as a traditional knowledge. For that matter, under different condition, it can be indigenous knowledge as well.
A question from Arjit Kundu, and the question is directly to Harish sir. Can you please elaborate on the point that how revocation of patent gives protection to traditional knowledge?
See, when somebody is trying to also come into obstruct your patent, then if their efforts to do that is revoked, then your patent is protected indirectly. Simple. It's like a possession of a property. If somebody is trying to interfere with your possession, you go take a temporary injunction, injuncting him from not interfering with your property. That's a protection. If I revoke somebody else trying to obtain patent on a similar thing, then you are already having patent for something. So or you are trying to get the prior user right registered through the patents law. Then you get protection if the other person's efforts are rejected. So you get protection. That's what it means.
Okay.
If you are trying to interfere with me, if I get you injunction against you, then I am protected with my possession of the patent. That's it. That's all.
I think so, sir. He got the answer. He is giving a big thanks to you.
Yeah.
Okay. The question is that what are the benefits of getting geographical indication, and who gets it and how?
Geographical indications are mostly nowadays it is mostly claimed by the various governments. Governments try to do it on behalf of the people. Muga silk, no one's individually owns a Muga silk. So it will be basically the government will be the applicant for the geographical indications, geographical indication registration. No one is owner of Muga silk. It is the state who is the owner. So state will be the, government will be the applicant for this.
But the recognition is like kind of a given to the entire community kind of a thing, no sir?
Yes, true.
Another question is that, is there any regional office in Assam or the entire Northeast so far for geographical indication or traditional knowledge or patent registration?
For patent and geographical indication, I can say yes, there is a patent registration office in it is on the bank of Digalipukuri in Guwahati. It is near to the High Court. It is near to the Cafe Coffee Day. Behind the Cafe Coffee Day, it is there. There is a regional office for the patent and geographical indication registration. But the traditional knowledge, we don't have a law to have an office. We can directly online go for the traditional knowledge registration with the WIPO. That is being, and I have been repeatedly saying that is being done in collaboration with Government of India. So we don't have any geographical indication registration. I'm not geographical, no, sorry, for the traditional knowledge registration.
Okay, sir.
But geographical indication registration and patent registration, yes, we have an office.
Okay, sir.
Yeah.
Sir, question directly to Harish sir again, sir. Is it, Harish sir?
Yeah.
Is it possible two different geographical indication tags can be available for two different states for the same product, as Assam is famous for Bukakhat Pera, okay, famous for Bukakhat Pera, and Agra has already its GI tag for its Pera?
I don't think so. Deka sir should have to pitch in also. I don't think so. See, if for Karnataka you have like Moga silk, it's one tag in the entire region of India. Another state cannot again apply for a similar thing because they start doing the same type of handicraft in their thing. Chanpatna toys, Mysore agarbatti. You cannot have different conflicting tags within the same region.
True.
But actually she means to say like Agra also has Pedha, which is made of.
So if Agra Peta has already got it, then the other one cannot get it.
No, I mean she means to say, I guess, like Mysore Pak is also like a Peda.
No, it is not Peda.
Okay.
I'll tell you one thing. See, Dharwad Peda can still take.
Dharwad Peda, yes.
Agra Peta. See, Agra Peda, it is not Peda, it is Peta.
Peta.
Dharwad Peda is Peda, it's Doodh.
Yes.
Okay.
Dharwad Peda is a Peda.
Yeah, Agra Peta is not from not from a milk product. It is from a pumpkin.
Not pumpkin, some other god, like a
ash god. Sorry, ash god, not pumpkin. Ash god. Sorry, it's from ash god. Whereas the peda is from a milk byproduct made out of milk. Okay, Doodh Peda there is a name called Doodh Peda. There is Dharwad Peda. So they are different from this Peta. This is Agra Peta made out of ash god. So Agra Peta, if it is different from the other one, then they can still Peda. They can still take, because Peda and Peta are two different things.
Sir, are matters of GI heard in different courts in India or in the civil courts?
Yeah, it can be heard. See, in Madras, in the original side, civil court, original side, a petition can be filed in High Court also. So it can be heard. Deka sir has got any other different view? Can
Yes, Deka sir.
Prasanjit, can you repeat the question? I did not hear it.
I am repeating it. Sir, are matters of geographical indication heard in different courts in India or in civil courts? That means he is actually asking this. He is actually asking the jurisdiction. regarding the subject matter of geographical indication?
Regarding jurisdiction, if it is registered in India and which part of, to which part of the country that GI registration belongs, it will be that way, and it will be heard in not in civil courts. It will be heard in the
High Court in original site.
Yeah, patent office and the original site. Yes.
Okay, I think so. He got the answer, sir.
Yeah.
Another question from Dr. Himavati. Sir, do we have a centralized system of geographical indication? If so, where is the head office?
Sir, Harish sir will take this question.
What is it, sir?
Prasenjit, Harish sir will take this question.
Sir,
Okay.
See, the government department is there for that. The central government department is there for this, sir. For this GI thing matters, you can go directly approach the central government department of trade and commerce in this.
Another question is that where is the head office regarding geographical indication registration?
It is again the patent office.
See, relevant jurisdictional patent office will be the office where you go approach with your grievance.
Yeah,
if you want to litigate, then you go to the High Court with original site jurisdiction.
Yes. But regarding jurisdiction, it will be the patent office located in the same location in the
geographical area.
So just for clarification, I'd like to add that for geographical indication as well as for patent, the office will be the same.
Same. Yeah.
Yes.
For trademarks, it is the
for
same.
For trademark also the same.
See, registry of trademarks.
Yes. There is one question for Harish sir. Who will get the benefit of GI?
Everybody in that entire nation. That's all. Beneficiaries
the state. Yeah.
The state and the its citizens are the beneficiaries. State gets the benefit of the credibility tag for its trade and commerce.
Yes.
Individual purchaser gets the authenticity of the product. I buy Moga silk, I am happy that I brought a branded silk. I buy Mysore sandalwood or Mysore silk saree, I get the authenticity of guarantee of the product because it's having GI. And foreigners come and buy from here and go. That is their memorabilia when they go there to say that I bought a Moga silk or bought Darjeeling tea. Darjeeling tea was the first GI product in the country.
Yes. So benefit goes to the people of the country, people of the state, through the state.
As well as to the country gets the credibility of the tag of a product.
Yes.
The purchaser, consumer gets the credibility of the and guarantee of the product, authenticity of the product.
True.
Sir, a question that okay, we have GI mark in the Moga silk. That is okay. But tomorrow someone does something misappropriate. They use some wrong marks to commit fraud on the people. Yes, sir. No, my question is yes, exactly, sir. But the question is that who can sue? It is the government of Assam. It is the people of Assam. It is the producer of that particular locality, or it may be any person who is a citizen of India.
Any person.
Affected party. Any affected party can urge their grievance before the appropriate forum.
So that means a person can Tamil Nadu can also file a suit.
See, if I buy a Tamil Nadu, if I buy a Mysore silk and if I am agreed by it, I still go because I went by the GI mark and the authenticity of the product, isn't it? And fraud was committed on me.
Yes, sir.
Deceptive similarity good was sold to me. Correct, no, sir? Deka, sir?
Yes, any aggrieved person in a criminal court.
Sir, another question that whether Kumol Chawal of Assam qualifies for geographical indication.
I will not be the right person for that because for geographical indication, certain specifications are to be followed. Hello, yeah. So
Yes,
the
yes,
patent
sir.
office, yeah. So the patent office will be the right office to decide whether Kumal Sawal of Assam can be the geographical indication or not. I am not following whether the specification as prescribed by the patent office, like whether Kumal Sawal will be qualified or not. I don't know the scientific specifications of the Kumal Sawal as well, and I have to see the where the place of origin Kumal Sawal. I don't know, like that Kumal Sawal can be produced in Burma or any other country. I don't know. I'm not following, so I'm not the right person to reply this.
Okay, sir. So basically, as per my knowledge, actually the rice that you require to prepare Kumal Chawal is very, very special, and it is produced only in Assam, and it also involves a bit of technology, and it also involves a bit of traditional knowledge. Actually, it's a combination of traditional knowledge. It's combination of place of origin of the particular raw material from which you can produce the Kumal Chawal. That is why my question came to my mind, and I have asked to you, sir. It was my personal question, sir.
So you see that it's a bit of traditional knowledge, bit of geographical indication. That will complicate it more.
Yes, sir.
That will complicate it more. So,
Okay.
I have got you have told us your knowledge about it, but when applications are made, only then the specifications can be seen. And like, if I say today that Kumal Chawla of Assam can be given the geographical indication registration, that means I am deciding the registration. So I don't want to take that privilege.
See,
Okay.
Prasenjit,
Yes,
regarding that
sir.
earlier question on going to action in courts,
Yes,
one more
yes.
thing. See, if a purchaser of a silk saree wants to go, is aggrieved by that GI indication thing, and it was fraudulently sold to him and thing, he need not even go to trademark registry. He did not even go to civil to the original side court. They can also go to consumer court. Deficiency, defectiveness in goods, deficiency of service, both are you can invoke even under the consumer protection law also.
Yes, sir.
Because as consumer, state may go to the other thing. This man can go to the nearest is the consumer forum.
Yes, sir. For deceiving the customers.
Yes.
So question is that whether writ can be filed for the protection of geographical indication. Whether writ can be filed for protection of geographical indication.
Geographical indication, now the question will come up whether that writ is whether that particular geographical indication is registered or unregistered, or it is both together. When we file a writ, whether it is both together, that will go for the protection of and geographical indication of a particular thing, or it is geographical indication together, all together. And I don't think at this stage we need any writ for the geographical indication, because already a system is there.
You can go up to passing off in courts under trademarks also.
True. Sir, I think that will confuse us more regarding the passing off and all. That will confuse us more.
But option is there.
I am taking a direct.
Okay.
Yes. I'm taking the direct question whether. Yes, true. That is true, sir. But I am taking the question like this: whether writ can be filed for protection of geographical indication. My answer would be no writ is required now, because already there is a system is there.
You have to exhaust all those channels if you want to go to court. You have to exhaust all these other levels of the ladder before you go to the higher court.
Sir, a question from Aninditya Day. It is not regarding geographical indication, but it is somehow connected to patent. I think so this question will be more appropriate in the next day session where we will be dealing with patent. But still, as the question has been put, I am just forwarding it to the resource persons. If I put watermark on my original writing or design, is it some kind of patent? What will be the technical term for watermark?
Prasenjit, can you repeat the question again?
Yes, sir, definitely. The question is, if I put watermark on my original writing or design, is it some kind of patent? What will be the technical term for watermark?
See, the question is confusing when the word design comes up. When the word design comes up. Now, this is a patent or she wants to do it under the designs.
Exactly.
So again, yes. Again, we cannot reply directly that it is. We can go for the patents, or we can go for the designs, because what she has done that needs to be seen. Through my eyes. Then the scientific specification.
Visible logo. It should be a visible logo.
Yes, that has to be seen. This question cannot be answered like this.
Sanjay, in this, she should know that you have hallmark, you have silk mark for silk products. Okay, that logo visibility should be there.
Yes.
Okay, then only you can get that.
Okay, sir. I hope she got the answer. It is very clear.
Mysore Agarbatti, the logo is being registered as part of the GI. So the logo is the most authentic one there.
Another question from Nitin Gahlot. Is it necessary that all works must be original in order to be protected under the Copyright Act 1957? And please explain sweat of the brow doctrine. Harish sir. Directly question to Harish sir.
What is it?
Is it necessary that all works must be original in order to be protected under the Copyright Act 1957? And please explain sweat of the brow doctrine. Harish sir.
No, see, once you write something that comes under copyright, you are the first creator of it. Original source. Okay. So by default you get, I pen something, tomorrow if somebody else try to write that, I can claim that, see, I had already done this earlier. All these script writers, story writers, screenplay people for the movies, how do they claim copyright? Because they would have already penned this in a book, and that without their permission is now going to be made a movie and things like that. So original creator is the person who gets the benefit. It always is that. So there's no dispute on that at all by any stretch of imagination. You see, in your under the water logo, watermark, you are asking, even your Moga silk is the logo which has got that GI indication also. Correct, no sir? Deka sir?
Yes, true. Yes, true.
Yes, Duita ma'am. I think so. We have completed our question answer session. All the answers have been given by our honorable resource persons. So we have just come to the conclusion of this particular session.
Thank you so much, Prasenjit. Thank you so much, Harish sir and Preeta.
Thank you, Deka sir. Nice to know you. Nice to interact with you. Thank you, Preeta. Thank you, Prasenjit. Thank you, all the participants. God bless you.
I have the pleasure to deliver the vote of thanks for today's session. So my heartfelt gratitude goes to Dr. Neelotpal Deka, sir. Thank you, sir, for your valuable content. I hope this will enlighten our participants. And I extend my heartfelt gratitude to Harish, sir, for joining us and for cooperation for today's session. Thank you, sir. And I also convey my heartfelt thanks to the chairperson and deputy chairperson for this session, and also thanks to the participant for your patience and for your cooperation. So here I would like to extend My thanks to the Prasenjit for cooperating in question hour. So thank you all. With this, I end this session today.
Thank you, sir. Thank you once again.
Thank you.